And now it's time for another case law update. The next case covers Clarke versus you, a contract dispute over an oral and implied joint venture agreement arising out of San Diego, California. Let's dive in. Clarke is a venture capitalist who previously worked with you, a chemistry chair and professor at the Scripps Research Institute, to fund and form biomedical research companies. In December 2021, Clarke contacted you about the possibility of creating a new company together. In response, you sought renewable funding to develop a new generation of technologies focused on carbon-hydrogen activation, commonly known as CH technology. Clarke and you named the potential company Change Pharma, Inc. However, 6 months later, you emailed to thank Clarke for his interest and efforts, but expressed his desire to explore other investors, as Clarke's proposed business and financial plan would not be sufficient for Change. Clarke then sued you, asserting claims for breach of an oral joint venture agreement, breach of an implied joint venture agreement, and quantum merit. You moved for summary judgment, and the trial court granted the motion. Clarke appealed. On appeal, the court decided whether the statute of frauds barred Clarke's claims for breach of an oral or implied joint venture agreement. Clarke argued that the statute of frauds did not bar his claims, while you argued it did. A joint venture involves an agreement with a commercial objective under which the parties have 1. A joint interest in a common business, 2. An understanding to share profits and losses, and 3. A right of joint control. However, any agreement that is not performed within a year from the agreement's making is subject to the statute of frauds. So, for any joint venture that will take longer than a year, the statute of frauds requires the agreement to be in writing. The court held in favor of you and upheld the trial court's grant of summary judgment. The court explained that there is no case in California law that exempted the statute of frauds from an oral or implied joint venture that, by its nature, could not be performed within a year. Further, both parties, through evidence and witnesses, agreed that developing the CH technology would take longer than a year, possibly multiple years. Commercializing the technology would take even longer. Because the potential joint venture would take longer than a year, the statute of frauds was triggered, and the alleged joint venture agreement needed to be in writing. The court concluded that because Clarke and you never formalized a written agreement to develop Change Pharma, such as a contract, the statute of frauds barred Clarke's claims for breach of the joint venture. The court then moved on to the next issue, Clarke's quantum merit claim against you. Quantum merit refers to the principle that the law implies a promise to pay for services. If a plaintiff justifiably relied on the belief that the defendant would pay for the requested performance, the plaintiff could recover his pay. However, this rule only applies if the services were rendered at the request of the person to be charged. Clarke argued that under quantum merit, he expected to be compensated for services he performed for you, such as securing a patent lawyer, preparing detailed business and technical plans, arranging meetings and travel, and finding other business partners. However, you never requested these services, and Clarke expected to be compensated by acquiring an interest in Change rather than by a cash payment from you, dooming Clarke's quantum merit claim. Overall, the court affirmed the trial court's grant of summary judgment against Clarke. So why does this matter? Emailing ideas or plans with a potential business partner is not sufficient. If you want to go into business with someone, you need to ensure that your business agreement is in writing to ensure that the agreement is legal in case future disputes arise. Our RNA advises on joint venture agreements and other business partnerships, ensuring you and your business partner enter into business together with confidence. That's all for today. I'd like to thank Frances Warden from our Denver office for her help with this update.